Knowing how and when to make an offer can make a huge difference in the outcome of your case. In this episode, we're going to talk about the things you may need to consider when making or receiving settlement offers, including Calderbank offers, Section 117C of the Family Law Act, and also practical tips on how to negotiate effectively to avoid those costly mistakes and protect yourself. Welcome, Mum.
Hello, Laura. Hi, everyone.
Now, making offers and receiving offers, it's literally like the whole point of divorce process, right?
It is. That's the absolute emphasis that the court's putting on. And you and your lawyers and the other side should be always trying to think of a way to end your case. And an offer might be the thing that will make it end.
So before we get into it, just going to remind you that Mum is not your lawyer. We don't know your full circumstances. So this isn't legal advice. This is just discussing legal education. If you'd like to learn more or if you need legal guidance, go and see a lawyer. All right, let's get to the jingle. Let's get started.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
So, Mum, I guess as we've just discussed before the jingle, it's literally your main aim for property or kids is to just get some sort of agreement locked in place. And as we talked about, by a consent order or binding financial agreement or a parenting plan or a parenting consent order, so that you don't end up having to go in front of a judge. That's really the whole point of an offer,
Yes,
right?
That's right. At least you don't have to go in front of the judge who has to make the final decision. You may be helped along your way by various other registrars and judicial officers, and they will keep encouraging you to settle. And the ultimate aim is to settle as soon as possible so that you avoid a lot of those court appearances and you don't get some person you don't know telling you and your ex how to divide your assets at great expense to you and your ex-partner probably.
Can I ask, are there KPIs for judges or justice or registrars or baby judges to get people to do offers? Like, is that a thing in the courts?
I can't say because I'm not privy to their contracts and things, but one would imagine so. I think that the overall central practice direction and the core principles of the court are to get matters settled as soon as possible and as cost effectively as possible and still do justice between the parties. And that, I think, is in everyone's mind who works in the court.
And that's everybody's goal. Like when I was going through it, I wanted to do it as cheaply as possible, as quickly as possible, and as painlessly as possible. So let's talk about, so we know that they're really important because it's how you kind of stop the continuation of court and all the drama and the uncertainty, the stress, the costs. So is there any point though in making an offer to your ex, if you know they're just going to say no because you've got one of those manipulative, controlling or high conflict that are just going to, or a narcissist type, or you're in post-separation abuse world, where they just want to keep stringing you along. So you know if you make an offer, they're going to say no. So what is the point in making it?
Well, here's the thing. For a start, you look good in the eyes of the court, ultimately, because you've been making offers. You can honestly say to the court, I've been trying to settle this. Yeah. But the more sort of actual thing is that they may actually accept it. You don't know that. Okay, so be careful what sort of offer you put, because if they accept it, you're stuck with it. So make sure you can live with it. But if they don't, if they really silly about it and they do not even either respond or accept the offer and it's a reasonable offer, then there's a little sting in the tail because you can wait and get at the final hearing. If they do the same as your offer or even slightly worse than your offer was, then you can say to the court, here, Your Honour, I made an offer way back in February 2025 and here it is. And the respondent or the applicant did not accept it. So we're only here because he was being unreasonable. From the day I made that offer on to the date of court, I would like the court to order that he pay my legal fees or she pay my legal fees, Your Honour, because we're only here because one of us was unreasonable.
Right. So even though you might think your ex isn't going to accept it, sometimes strategically it can be a good thing because then you can get your costs paid. And we do have a really good episode on Calderbank offers and costs. And we're going to talk about it today as well, but that is also a good one to listen to. And Mum, I know you want to say that it's not all your costs.
Oh, you know me so well. Exactly. What the court, you'll hear the expression party and party costs. And I got very excited about reading that when I was a young law student. But in fact, it doesn't mean what it says. There's no parties involved in the fun sense, but there's a certain number of actions that your lawyers have to take in regard to the other person. And those are party and party costs between you as a party and between them as a party. And so it doesn't cover the costs of you having legal advice or phone calls and things like that. So generally, rule of thumb, you should, if the court accepts that you're entitled to costs, you probably get about a third of them back. But it's not a bad thing as long as you're not the one having to pay it.
Does that then make it really important to document your negotiations? Because obviously you can't really prove that you made that offer. It's not in writing.
Yeah, if you didn't make it in writing, you can't raise it before the court because everyone would. So they're not going to accept that. They're not going to believe it. The court, you have to have it in writing. There's not a particular form for putting an offer to the other side, but it does need to be in writing. And it does need to be capable of being accepted, so clear, and it finishes at least one aspect or all aspects of your matter. And the other person has to have enough information to enable them to make a choice as to whether accepting it, as to accept it or to not accept it.
Right. So there's no proper form for it, Mum, but it's important that you document it because that's how you prove it later that you made an offer.
That's right. And I think that one of the best tips that I received and I pass on to everybody is if you're writing to your ex about something and you want to include an offer, put all the explanation of how you reached the offer, you know, what your point of view is, and if you've got any cases supporting and your argument about it, but attach or put the offer as a separate document so that when the time comes, if you ever have to use that offer to get your cost, right, in the court, you've got a clean it's 1 or 2 pages with clearly set out orders and no extra material in it, no snarkiness or no explanation. It's just the numbers. Yeah.
Okay.
Yeah.
All right. So settlement offers are important for that reason. And even if you think your ex isn't going to accept it, sometimes it can be helpful because it can come back later and bite them in the bum. If the judge offers an option that is similar to or worse than what you'd offered originally. Yeah. Is that true for children's matters as well as financial?
So it didn't used to be, but you can do offers in children's matters, which is a little bit distasteful. But when you think about it, the court process is just as draining, you know. Right. Yeah, so do you know what else I always do, Laura, is I always send a copy of Section 117 of the Family Law Act, and in particular 117C of the Family Law Act, to the person. You're not writing it to the lawyer because they already know, but you attach it to the letter that lawyer will have to give to the other person. And it has that section in there about costs and the risk, because your ex-partner might not realise how dangerous an offer is with its implications for them maybe having to pay your costs. So other times I put the section of the Act in the body of the letter that's separate to the offer but goes at the same time, so that your ex gets the full effect of what might happen in case their lawyer doesn't really emphasise that risk to them.
Right. So if anyone's interested in looking at Section 117C of the Family Law Act, we'll pop it in the show notes, but you can also find it just by searching for Section 117C of the
Yes.
Assuming maybe that amicable and avoidant people have an easier ride, they do get an agreement, they've set their offer, they say, yes, we agree. What are the next steps, just quickly, before we go on to some more stuff?
So if they accept your offer, then hopefully you've sent it in a form that can just be turned into consent orders, signed and lodged with the court. And if you're already been to court once or twice and that you're able to reach a settlement, you sign those consent orders, you send them to the last judicial officer you were in front of or the associate of, So if you've been only to the first court event, that registrar, you'll send those consent orders to them. You send them to whoever sent you to mediation, if they have. And then if a registrar agrees that the orders are fair and reasonable, just and equitable in the case of property, or in the best interests of the children in the case of children, then that registrar may sign or stamp those orders and they turn into orders of the court. And then everything stops.
Now, I get this question a bit in our member Q&A, so I'm going to ask it here for the benefit of anyone who is in court. If you get an offer, you accept it, and you've still got a court date coming up, do you still have to go?
Yes. So when a court makes a date for you and makes an order that you attend, heaven help you if you don't, okay? You can, you've got a couple of options usually. One is to scramble like crazy to get the document drawn up and signed and lodged at the court in time, which might terminate the thing. I don't want anyone, though, rushing into that. If without proper consideration, you need to go and see a lawyer. You need to know exactly what the orders mean, and it's too late to worry about it later if you didn't really think it through. The second way that you can deal with it is to write a very respectful letter signed by you and your ex to the associate or assistant of the last judicial officer you were before, or before whom you have to appear next time. And their addresses are usually on the website for the FCFCOA, Federal Circuit Court, and Family Court of Australia. And then they will show it to the judge or the registrar or whoever who was last in the case, and they may make those orders and vacate the date. But many at the time, I've been involved in cases where we negotiate up to the 11th hour, right? Just before 4 o'clock or just before 5 o'clock the night before. You've got consent orders. You still need to be ready, turn up at court, because those orders, even if you email them, may not have reached your judge or your registrar yet. And so you can turn up, the other person's side turns up, and you can ask the court to make those orders then and there, and they might do that.
Can that save you money? Because isn't it like $1,000-something to get consent orders filed? If you get the judge to do it instead.
Where you're saving money, Laura, is that the documents to apply for consent orders, right, usually are lodged where there's no other documents before the court. So it's in place of an initiating application, and it has to have all that information in it so the court can make a reasonable, just and equitable decision. And the court must not make an order unless it is just and equitable. But when you've already had your initiating application, financial statements, affidavits, responses filed, they don't need that application. You're already before the court. Bless you.
Oh, true.
And so they just are able to read that letter. Usually someone has to write a letter of justice and equity, explaining how the orders address like property, why it's fair. If one person's getting less than they should, it might be that person's just gone, you know what? Expense, delay, uncertainty, my emotional health, it's not worth it. I'm going to spend $70,000 in court to get $80,000. So not good. So you can explain that to the court. And if you've got kids' orders that you've reached by consent, the court will want you to expressly state in that covering letter how the orders that you've got for the children protect them from the dangers that you may have identified in your notice of risk or the other person may have identified. So it's not just a rubber stamp.
All right. So we went a little bit past making offers and accepting offers, but let's go back to when is the best time to make the offer? Is it before filing, after mediation, pre-trial? Like when do you usually make offers?
I think that people should make offers and the court expects them to make offers as soon as they have ascertained or worked out what the property pool is, and enough so that they can assume what a judge is going to order based on that evidence. So it's really hard to make an offer before you've had disclosure.
Right.
Because you don't know. But you might not need all of the disclosure that your lawyer is looking for, or you might not need full disclosure. You may have enough information. The minute you think you've got enough information, then that you can make an order and both of you can assess if it's what it means in terms of the whole property pool. I suggest doing it then. And sometimes if you've got a completely stubborn person on the other side, if you think you know what you want to settle in and they're not cooperating, send them an offer. And that puts the onus on them then to protect themselves from a costs order.
So I'm sure you used to say send an offer after mediation.
Oh, you do. You always do. If you've had mediation and you reached almost agreement and someone stormed out, or you were all too tired to agree and then they backpedaled or whatever, still send an offer after mediation. And you should be closer to understanding the entire picture then. So try to send an offer then. The court requires you, the central practice direction occasionally requires you to send offers. The important thing is that, and this is education only, but wouldn't want to be going to a mediation until I had enough information to make a decision on that night or that day. And therefore, I'm assuming people have got enough information then to make offers. And the first thing you do in mediation after the opening statements is one of you makes an offer. And it's not going to be what's in your application. Usually it'll be something slightly better.
Can timing influence the legal costs if you make your offer? So if it's sooner, that becomes more of your cost.
So like what I was saying, you're on it way back in February. What if February 25 I made this offer? The court actually says, okay, what costs have you incurred from February 25? Okay.
Right.
And if you were able to say I made an offer way back in October 2024, well, the court will go, all right, what costs have you spent between October 24 and now? So the earlier, the better, as long as you know what you put in, what the property pool is, and you're comfortable if they accept the offer. So don't ever put an offer in thinking, oh, well, they won't accept it. So I'll make it good and generous to them because then I'll get costs at the end, because they may just turn around and accept it.
I have heard some people go, should I make offers like you do when you're bargaining on Facebook Marketplace where you lowball or you highball? Or is that so that you're leaving room for them to knock you down? Is that something that people do in the legal offering stage of them?
They do in mediation, Laura.
Okay.
But don't do it in your offers documents. That's my recommendation. Put a genuine offer. You'll see that mentioned in the central practice direction. And the court is really against what they call ambit claims, where you just go, I want 25% of everything, So they want precision in the orders and the offers, and they don't want you playing silly so-and-sos with your offers. But inside a mediation, of course, you might think your ex's price point is maybe 55, and at the moment they're only offering 50, say 50. You might say, well, I'll have 60, hoping like heck that they'll go, oh, well, the midway point between that's 55, and they'll come back with 55 for you. So those are all negotiation tactics that won't get you in trouble, but you're not putting things in writing that can appear in court. So you're able to use just normal negotiating tactics. But the purpose of a written offer, it's got to be a genuine offer. And if it's a genuine offer, it should be somewhere around what the court will order.
Okay. So where settlement offers should be made, so formal written orders, so by a lawyer, email, or official correspondence, and they're the ones where you are genuinely, that's what you want. That's not highballing or lowballing and hoping for the best.
Yeah.
But at mediation, you've got the freedom to negotiate effectively and play the car salesman game, because if that's what you want to do, I wouldn't recommend it. But if that's what you want to do, it's not going to come in front of a court because it's all worse.
I think that's transactional bargaining. That's what you do. But be careful. With the offer, you said you put in that genuine offer of what you genuinely want.
Yeah.
I think, Laura, the better expression is what you genuinely can live with.
Yes. Yeah, and I think that making an offer, and I'm just going to talk from experience here, like you really need to sit down, and it's not just something that the numbers put together and you get that and you go, okay, cool, I'll make that offer. You have to think about it, because you do not want to make an offer that if they accept it, you then go, oh, I really wish they hadn't have accepted that. So you don't want to play with your future without heavily thinking about it, really sitting down and looking at your life, your children's lives, what the consequences are, what are the outcomes, what's the worst case scenario, what's the best case scenario, and can you live with that? And like you said, Mum, the living with is such an important question to ask yourself before making an offer.
That's right.
And I do sometimes think that I've seen a lot of people get pushed into accepting offers or making offers by their lawyers, no offense to lawyers, or judges or justices or registrars or whatever, because they see that's the right thing to do, but mentally you might not be there yet to accept it. It may take some time for you to sit down and process it all and go, okay, I see that's fair because they have more future needs than me, or I did the more contributing, or I got this or my health is really struggling, so I understand this and this is why it needs to be. But if someone's just trying to ram it down your throat saying, take the offer, hurry up, and you haven't learnt and understood why the offer is what the offer you're meant to be, it can feel unfair and it can cause you to continue fighting for longer. So don't rely on your lawyer to do all the work. You have to do some of the work to get yourself mentally, I think is what I'm trying to say.
I think that's very true. That's very true. And sometimes the stuff that clients and me when I was there, and you no doubt when you're in that situation, what we thought was so important, the lawyers listened, went, and then never mentioned it again, And I think that rankles with people because how could they have made a proper order? They didn't know about my grandma's crystal vases, or they didn't understand about the jelly molds from Tupperware. And whilst the court, your lawyer's hearing facts from you, and then they go, relevant, not relevant, in their mind, okay? But for you, it's all relevant. And so it's such a good point, Laura, to do that. You've got to get your head around it and accept some of the change.
Well, people's sense of natural justice and what you think would be fair in the family law court isn't necessarily what is fair in the court. And so your understanding of natural justice is like an example. I'm sure anyone who has seen a lawyer or is talking to a friend who has nothing to do with divorce will go, well, surely that's not true. That doesn't make sense. That's not fair. Welcome to the world of family law. It's just they've got their rules, they've got their legislation. It is what it is. And it doesn't match with what people think is fair. Like, there's a lot of people that email and say, well, I made all the money, I should keep all the money. There's a lot of attitudes that do cause problems with understanding what the offer is fair or not. So it's fair in the court's eyes, not fair in your eyes.
And in defence of the court, they've got to follow the rules and they've got to follow the Family Law Act. But here's the thing. You only know about you and your future, particularly given the history you've separated from this person. There may be bitterness there, or you may be scared going forward. It's very hard for you to put yourself in the other person's shoes, but they similarly can't understand why you're going on about it because they're just seeing their side. So, you do need either a meeting of the minds, as they say in law, between you and them, and you can both go, well, it's not perfect, I can live with it, I guess. If that's how both of you leave a mediation, or that's brilliant. That's exactly what you want. If you leave a mediation going I'm so happy, I really got more than I ever should have got, chances are the other person won't ultimately sign any orders. They won't be happy. And if you walk out with less than you can live with, and this is what I mean by live with, Laura. You accept it, it's over, right? Are you going to lie there at night going, why did I let that go? Why didn't I fight for more? How come I'm doing all of this and they've gotten away with it? And the awful thing about it is you'll be beating yourself up and it spoils your future, okay? So you have to, that rationalising that you said, Laura, that coming to grips with it, getting your head around it and accepting it has to happen at the time of the offer, or you will regret it going forward. And there's no one subsequently, like after that's gone, your lawyers have gone, there's no one to say, no, mate, really, if you'd gone any further, this might happen. So you're just, and like you say, lay people, like your family and your mother, and not in your case, your mother's a brilliant person, but your best friends who may have formed a view about your ex may be completely blindsided by a settlement that you've reached. And then they quit. Well, what about this? And did you forget this? And what about that? And all of that effort. And I remember this. And so you don't only have to get your head around it. You have to be ready sometimes to defend your choices in front of or with the people who know you very well. So you can either go home and say, I'm not discussing it, but we've settled, which is a great way of doing it. And I can live with the outcome. Yeah. Or you have to be prepared to kind of explain to them. And mediation's a process, and offers are a process. And if they haven't walked the walk with you, and they don't understand the pain that you might go through if you go all the way to trial, it's really hard to drag your friends and relatives with you in this journey.
Look, and I totally agree, but I am going to add, we've left out a little category of people who I know listen to this podcast, and they're the people who aren't thinking about themselves at all when it comes to the offer. And they're sitting down, instead of thinking about, is this something I can live with moving forward? Is this something I'm going to regret? Is this something that is manageable? They're thinking, is my ex going to be okay? Is my ex going to hate me? Is his family going to hate me? And they're not actually thinking about themselves, or they may feel guilty because they left. And we hear of these people who get offered something and they accept it out of guilt. They sign the consent orders, and then a year later, they're kicking themselves. So you've got to make sure that you are also accepting offers genuinely for yourself, not for them.
Well, if you have been involved with the person who's controlling and manipulative, they may have been through relationships before that have failed because they're not probably ideal partners for people. And so many times they repartner quite quickly as a rule. And then you will have either walked beside your ex while they do their breaking it up and negotiations with their former partner. You haven't ever met the former partner, but your ex has told you what an awful person that person was and how they took them for everything, or they didn't provide for them properly. And so when your turn comes to separate from this person, you've already been conditioned to not be like their ex, And I hear that, and it takes time. I always say this, but sometimes I think it would be compulsory to meet someone's ex face to face, because we're getting like serial offenders here doing things like that. But yeah, you're right, Laura. And those people
in Facebook groups, though.
What's that?
There's a Facebook group apparently called "Is Someone Dating My Ex?" Are we dating the same person as well?
Yes.
Do not recommend it. We do not endorse it, but it's out there.
I'm not going to look. It'll upset the algorithm.
We're getting completely sided by talking about this, but it's so important.
Yep.
But Mum, what does without prejudice discussions mean?
You're invited to our free webinar. Whether you're stuck at the beginning of deciding to divorce, or you're struggling to find your way through the legal jargon and fear of the unknown of the legal process, we are here to empower you to take control. Join us to learn what steps you can take, followed by a live Q&A where you get Lynn, my amazing mum, and family law accredited specialist to answer your questions. All you have to do is go to www.thedivorcecourse.com.au and click on Reserve My Seat. We'll see you there. Hurry, spaces are limited, so don't miss out. Register today.
But Mum, what does without prejudice discussions mean?
Okay, it simply means that everything in that letter that you've written without prejudice, assuming it contains an offer, can't be revealed to the court. So that if you're in the middle of negotiations, say 5 nights versus 6 nights, and at some time you already had offered 5 nights and 7 nights, say, and at some time stage you'd already offered to only have 6 nights, you can't say to the court when they're in court, they've already agreed to 6 nights. You can't do that. You can only put it up to the judge as an offer when you're talking about costs at the end of a proceeding.
Okay, so let's just make this really clear. So say, for example, in a letter that had without prejudice on it, you offered week on, week off, and then negotiating further on, you change your mind because you found out some really bad stuff about the parent, and so you change it to 2 nights a fortnight.
Yes.
Like, this is extreme difference. But that's because it's all without prejudice. That if you're during your trial, they can't say, well, she originally or he originally offered week on, week off. You can't say that because you've got the without prejudice, but you can show it to the judge once you've got your final orders.
Yes, a property offer might have been a better example, Rosie, because with children, there is this overriding thing about the best interests of the children. But yes, so you can't really put offers up to the court unless for costs. Do you know what we haven't talked about is what if you get an offer?
Yeah, we're getting to that. Let's just talk firstly on how to make a strong offer. Have you got any quick tips on what to include? They talk about the Calderbank to make it reasonable, and how do you make your strongest, best offer, Mum? What do you usually do?
I like to, first of all, put the actual proposal in the first part of the letter. I would like to make, or my client would like to make, my client makes the following offer, ... right? You keep the house, ... You pay her this much, ... Each keep their super or divide the super, so that the salient points are there at a glimpse and you keep white space around it. Then the actual doing of it, the document of orders that if you signed it would give effect to that sort of thing, I attach those as well, so that, because you've heard the expression, the devil is in the detail. So what I do is I'm giving them a snapshot. They can open the letter, open the email and see instantly it's an offer and see what the gist of it is. Because I don't know if any of our listeners have seen court orders, but they are...
The pages long.
They are. And they're heavy reading and they don't really seem to get to the point.
Doesn't seem to be the English language.
It doesn't. Yes. Yeah, that's right. And so the bit about who keeps the house might take 8 or 9 paragraphs and you'll have to scan it and then you're like, oh, well, what about the rest of the stuff? So a little ... helps, I think.
Okay. All right. Now let's get into receiving and responding to orders. What if you receive? How do you know if an offer is fair?
Get some legal advice, okay? As long as you've had enough disclosure or you've had whatever professional information you need, whether it's been a family report or whatever, if you've got enough information, then get some legal advice about whether or not to accept that offer. Because if you don't, and it is later on the same as what the court orders or better for you than what the court orders, then the other side is going to leap up and say, Your Honour, this is the reason we're in court. I want my costs from the date that I filed that or gave that offer to the other person to now, and they'll get their party and party costs. Maybe, if the judge is inclined.
So I do see and hear this in our member Q&A, and people write in and they're panicking. They've received an offer. They got it on Friday at 5 o'clock, as lawyers do. And they said, it's given me 24 hours to agree, or 4 minutes to 5. It's given me 24 hours to agree to this offer. And they say, if I don't agree to this offer, it's off the table. What do I do? Blah, blah, blah. So, Mum, when it comes to offers, are they allowed to put time limits on them?
People do, but the court has to be able to look at the offer and see if it was reasonable. And that doesn't mean reasonable in the outcome, but also reasonable in the time frame for the person to assess the offer and look at the offers. So that 5 to 5 on Friday, that's the trick that a lot of lawyers use, and it's very bad form, because if your lawyer just flicks it to you or their secretary flicks it to you, that's going to give you heart palpitations for the weekend, right? It's not fair and it's a dirty trick. So if you get one of those, maybe send a letter back saying, thank you for your offer. I need time to consider it, and then give them a date by which you will respond. And really, if they ever show that letter to the court, you will have your letter to them saying, give you time to consider it, and so you can stall. Or if 7 days, sometimes they need you 7 days and you can't make a decision because you don't have all the documents. And so quickly you need to write back and say, like, within that 7 days.
You see a lawyer
and get them to write a letter back saying something like, I want to consider your offer, but so that I can get proper advice or properly be advised about it, can you give me these documents, please? This, and
or can you need more time?
If you need more time, yes, you might say, I'm seeing a lawyer on Friday or Thursday, and I need some time to respond. But for sake, respond, right? You've got to respond. Don't leave it hanging around with no response from you. And then a lot of people do these offers where they're only on offer for a week or 3 weeks, and then we're pulling it off the table. And sometimes that's a legitimate process to do because, for instance, let's just say you're coming up for trial, right? And you've got solicitors and you've got a barrister, but you haven't yet locked in the barrister for this 3-day trial. The minute you do, you could well be up for their entire fees, as well as all of your lawyer's fees and maybe airfares and things. So you could say, look, this is my offer today, but on Thursday of next week, I will be required to brief counsel and incur those costs. So this offer only lasts until that date, and then you put another offer in after that date. I think it's always good, if you can, to have an offer around, on the table so that you can, you're protected.
If you get an offer, it's close, it's really close, but it's not quite there. Can you make a counter offer, or is that something that's done?
You can. So the law of contract, which was many moons ago, we learned this. A contract is a contract if someone offers something and the other person accepts it as is. If one person offers something and the other person says, yeah, but can I add this as well? Then that's not accepting the offer. It's a counter offer. And so you may risk the whole lot falling out. Or it may be that you could say to yourself, what they've offered is good as far as it goes, but it hasn't dealt with, the car, right? Or it hasn't dealt with school holidays. So you may say, I accept the offer as far as that part of the offer, but in relation to the car, this is what I propose. So, if they haven't done anything, haven't mentioned something in there, you can probably see if you can, they call that narrowing the issues, and you may end up at trial fighting just over the car. But if you said, Laura, to me, there's one teeny little thing that I'm not accepting, think about if that's worth the expense, the uncertainty, and the stress of a trial. Sometimes with kids, that's not even it's not a tiny issue. It mightn't seem like much, but it's not a little issue. But with property, remember all your furniture's secondhand. If you have more money today, you can buy something before the prices go up maybe. If you reach consent orders, you're less likely to have it appealed by either of you, and the court can make them on the day. So there's a lot to be said for that.
Okay, that's good to keep in mind. And again, what Mum is saying is nothing that you should do unless you've seen a lawyer first and talk your individual circumstances. Mum, is there a risk? And this is to all our avoidants out there. Hello, I remember being one, so feel for you. Is there a risk of ignoring an offer?
You mustn't ignore an offer. I don't think you should ignore an offer.
Right.
But then the options are accept, reject, ignore, or counter offer. So it's 4.
What if offer is just so ridiculous? Like the offer is, for an example, because like you said, children is really hard to be like a bit.
Yes, you can't be sensible. You can't be sensible and negotiable.
Offer is that the parent will have the child 100% of the time and you don't. Like that's not really an offer, but what if they write you that offer? How do you, without losing your biscuits, like respond to that?
So you don't respond, I think, to such a silly offer in terms of getting upset. You just logically say, no, here's my counter offer. And you might even put a little explanation in your covering letter of why their thing won't work and then have a counter offer. So I think it's always important to have a counter offer, even if you reject their offer, put a counter offer in, unless you really can't work things out because you don't have all the information, in which case you say, I'd like to consider your offer, but I don't have all the information that I need.
Okay. We're just going to quickly touch on this because I'm aware of the time and we've done a whole episode on it and I'll put it in the show notes. But what's the role of Section 117C of the Family Law Act in determining costs if an offer is unreasonably rejected?
It's one of the factors that the court will take into account. If someone makes an application for costs at the end of the court case, then the court, one of the things they can take into account is whether there's been an offer made. And that's usually the thing that they look at for costs. But there's also the conduct of a person, whether the trial went longer because of the non-cooperation of a person. There's all sorts of reasons. So you don't just get costs if there's a cost order. If there's an offer, there are other behaviours that you might get costs. And where people might encounter this is if you have to go to court because your ex won't cooperate with mediation or won't give you disclosure and you have to go to court to make them. Your first, normally I would expect a person to be saying, Your Honour, could I have my costs of today? That's if you've incurred any costs. Because we're only here because that other person would not do the things they're required to do at law. Didn't give me the document. I had to come here to get any movement out of them. So, and I'm seeing more and more where the courts will go, you're right, I'll award costs and I'll fix it. Sometimes they fix it in a sum of a few thousand or tens of thousands. I don't know. Depends. Wow. But they do it. They're seeming to do it. The court is seeming to do it now at the early stages to kind of rein in anyone who thinks that it's not serious and it's not important.
So those post-separation abuse, legal abuse kind of cowgirls, that's going to affect them because if they get cost whacked on them at the early stages, they probably think twice before being silly later on, hopefully.
Yes, and I've seen that time and time again where they get one sort of cost order and it's not a rap over the knuckles, it's money. And then you'll find they're a lot more cooperative going forward.
Well, money does talk to people. Now, Mum, last one before we just do some quick tips on settlement negotiations. Who should be involved in settlement offers? I think this is really important because I would hate for anyone listening today to accept an offer or offer an offer without seeing a lawyer at least.
Yes.
But I think there are some other people that potentially should be involved. Who else would you recommend your clients go and see before they accept an personal property?
If it's financial and if there are companies involved or trusts involved or self-managed super funds, please, please, please go and get some financial advice about the impact of that offer. There are often taxation consequences in something that seems easy. You can put it in the letter, it seems easy, we'll write it, and then in a year's time or 6 months' time, suddenly you get a bill from the tax department because it offends your agreement offended Division 7A of the Tax Act. So see a financial advisor, see your lawyer, someone who's not upset and in the hole with you. If you're upset, you'll know the one who's sort of more objective outside, maybe talk it over with them, but it is you. So you have to live with it. You have to make it work for you and your family. And sometimes it's best just to keep it to you and your financial advisor and your legal advisor. And like I suggested before, Laura, just say to the other members that you're working it through and you've reached an agreement, you've reached something you can both live with. That's probably all they need to know because you've got enough energy and strength to get you through this, hopefully, and your children through this. But I don't think you've got any bandwidth available to get your rellies or your mates through it as well.
Should I be a little controversial? Because we haven't mentioned a party that may be quite involved. And that is if you've repartnered. You may have repartnered or they have repartnered. And it changes the dynamic of negotiation, especially children's matters. It does change the dynamics. And we get emails from the partners asking questions for their partner.
Yeah.
So I do see that people heavily get involved, and I understand you'd want to support your partner going through a divorce process. I totally get that. But Mum, do you ever see that getting in the way of it sometimes?
I see red flags when that happens. If I can't get a person, when you see people face to face, if I couldn't get that person in the room without their new partner, I'd think, here we go. This is a control situation, and I would throw the other person out. You have to make this agreement yourself. You've got to live with it. You can discuss it maybe but ultimately you are you, and don't hand your power over to a new partner. You pull up your big girl or big boy pants and it's up to you ultimately.
Well, it's not only that, because we're about to talk about the quick tips for settlement negotiation, but sometimes one of the tips is keep the emotion out of the process and just focus on fairness and practicality and just the law, the facts.
And the law.
The family law.
Yep.
Have a look at the laws. It's really hard to keep the emotion out for some of these people. You see these new partners and they're maybe livid because of the horrible things that person's put their partner through, or then they've had a fight with the new girlfriend or the new boyfriend and it's causing all sorts of dramas, and so they want to get back at them. So trying to keep the emotion out of it when you've got two emotional people on there is pretty tricky.
Well, here's the thing. It's not about them. They may have an axe to grind, but they can just butt out because it's nothing to do with them. And sometimes they get in a competition with the old partner. It might be from their insecurity, or it might be that they are coercive controls themselves and they want to invade that area. You're like, I don't think, here I'm going to be controversial. I can't think of a case where the new partner, one case, where the new partner in one case only ever added something and assisted my client in the overall settlement of the case.
Okay.
So the other person is they should be there to support you for sure, but don't let them take it over. And it's not about them. And if that's what they're making it about them, have a little think about your choice of partner.
Mm-hmm. All right. So who should be involved in your settlement offers? It should be you, your lawyer,
financial
mediator, and your financial advisor and tax accountant.
And not your kids.
And not your kids.
And not your new partner. And not your mum and brothers and sisters. And when it comes to an offer, it's you.
The next thing we're just going to quickly touch on is some tips for settlement negotiations, successful settlement negotiations. So we've said, number one, keep the emotion out of it. Focus on the fairness, the practicality, and the Family Law Act. I mean, just look at the black and white.
Cases.
Number two, always get legal advice. Do not do anything unless you've seen a lawyer. If you can't afford a lawyer, go to a community legal services, legal aid. There's so many other options out there to at least go and see someone once and say, here's this offer they've given me. Here's all the facts. Is this okay? At least see someone. Document everything, Matt?
Yeah.
Written communication?
Yes, I think so. And particularly if you've received an offer and you want to make a counter offer and their offer is in writing, by gum, you better put it in writing because because the court wants to look at the whole string of correspondence usually. And if they put an offer, they hold that up to the judge. You can say, but Your Honour, here's my response. But you can't go, but Your Honour, I told them that, So in writing.
All right. Next one is understand the potential consequences of rejecting a reasonable offer.
Yes. And if your ex has got barristers and solicitors involved, even if you are self-represented, you may end up paying for some of their barristers and lawyers' costs, okay? So it's false economy to not go and see a lawyer and get some advice.
And lastly, consider the long-term implications before you sign any.
Yeah. I think there's one more tip, Laura. When we look at what your likely outcome is in court, there's always, as one mediator always puts it, there's your bright, shiny case outcome where absolutely everything goes perfectly and your ex behaves terribly and the judge just loves you and gives you everything you want. I don't think those cases exist. And then there is the really terrible case where everything goes wrong, where your ex is able to portray a lovely person in the witness box, where you get caught out maybe stumbling or misunderstood something or maybe lied, or one of your witnesses doesn't come up. Yep. And so that terrible option could be 10% lower than your bright, shiny case. So don't just think what your bright, shiny case outcome would be. Think about the range of outcomes you may have with the same facts, but just how it goes on the day. That's
okay. Thank you. That's just think about your worst case scenario, your best case scenario, if it fits in there, because that's right. Things happen. Things happen on the day that you never know could happen.
And if you have your worst day, then not only do you get less from the judge, but you may have to pay costs for them as well. So you've had to pay money to get less. It's just yes. So do your research when you get an offer.
Yeah. All right. Well, thank you, Mark, for sharing your wisdom today. Good luck to anybody out there right now who is thinking about sending an offer, who has received an offer, or is just facing the whole process anyway, and they know that the offers are on their way. We wish you all the best of luck. Again, please go see a lawyer. Do not make any decision based on this podcast episode. But Mum, I'm sure you're with me in saying that it's a hard thing to do, but we know you can do it and we wish you all the best.
Yes.
Thanks, Mum. Bye.
Bye, Laura. Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.